Good morning, everyone, and welcome to Gough Square Live, which, as you might have suspected, is coming to you live from Gough Square Chambers. Today, I'll be talking with Simon Popplewell, who's going to talk to you about the definition of consumer, as recently interpreted by the Court of Justice of the European Union, in a case which I'm going to call Petruchova, and you'll hear the Mancunian pronunciation of that shortly. As usual, there's a live chat. Do send any questions in and I shall do my best to read them from this monitor in front of me. You can also send messages by email to goughsquarevl@gmail.com. So without more ado, I'm going to ask Simon to tell you all about the definition of consumer.
Thank you, Ian. I'm going to talk about what the word consumer means, a topic of obvious importance to anyone doing consumer law. I'm going to start with some of the legislation. I'm going to take you through a little tour of some of the case law. I'm then going to try and pronounce the name of the case which Ian has just mentioned, and I will see how I would do. And then finally, at the end of this, I will identify a few sort of situations and try and give you what I think is my opinion on whether they would or would not fall the right side of the line, or whether someone is acting as a consumer or not. For those of you who have the slides, if you look at slide 1, you will see I have reproduced one of the definitions of consumer there, which is the one you will find in subsection 2.3 of the Consumer Rights Act. There are obviously more than one definition of consumer around. I had to plump for one, I went for that one, but given that it derives from European directives, given that a lot of UK consumer protection legislation derives from European directives, it's very similar to definitions you see elsewhere. For example, it's identical to the definition of consumer in the Consumer Contracts Information Cancellation and Additional Charges Regulations 2013. It's very similar to the definition of consumer in CPUT, which just refers to someone acting outside his business. And it's not that far apart from some of the definitions of consumer you had in UK legislation which predated European directives. For example, under the Unfair Contract Terms Act, somebody is acting as a consumer if they're not making into contract in the course of their business or holding themselves out to do so, and the goods or services which they are buying are the type of debtors you would ordinarily find for private consumption. Looking then at this definition in the Consumer Rights Act, you will see to be a consumer you have to be an individual. So a body corporate can't be a consumer for the purpose of the Consumer Rights Act. That is slightly different in UCTA, but you can be a company. But for the Consumer Rights Act, you have to be an individual. It will see partnerships will fall outside the scope. There's a bit of a grey area about unincorporated associations, but there is at least one French decision interpreting the Directive on Unfair Contract Terms that suggests that for unincorporated associations as well, they're not an individual, therefore they can't be a consumer. So what we're looking at is natural persons, you, me, Ian, etc. Definition also involves you having to act mainly outside your individual's trade, business, craft or profession, not just business purposes. If you're acting for purposes which are to do with your job, then you are not a consumer because you are not acting mainly outside the purpose of your job. When I go and buy my wig and gown when I'm in court, I'm acting for the purpose of my job. I'm not acting as a consumer. What about a director giving a director's guarantee? They are probably doing so for the purpose of their directorship. If that is part of their profession, then they are acting not as a consumer. When Ian goes and purchases his very fancy suit that he is now wearing, is he doing so because that's what he likes to wear on the weekend? Probably not. He's doing it because he's probably wearing it for the purpose of his profession. It's at least arguable that therefore he's not acting as a consumer, which seems a little bit counterintuitive. You probably think if you go to a clothes shop and you buy something to wear, you'd be acting as a consumer. But there is an argument there. So the definition of consumer, it's wider than just business. It will include craft, profession, your job. Okay then, if you have the slides, if you go through to slide 2, you will see my start of the journey through the case law. The first one is a UK decision, R&B Customs Brokers against United Dominions Trust Limited. This was a case under the Sale of Goods Act. There was a gentleman who was a director of a company who found a car which he wanted to buy, but he didn't buy it himself. He used his company to purchase the car for him. And the question arose, well, did he do so or did the company do so as a consumer, given that it was a purchase by the company, in essence, for the use of the director? And the UK court said, yes, the company was acting as a consumer. They took quite a wide notion of what constitutes a consumer. And they said that a business is still acting as a consumer if the purchase that it makes is not an integral part of the business. This was a customer's business, so purchasing motor cars wasn't integral to it. And if it was a incidental purchase, like this was, it needed to be carried out with some degree of regularity before it became part of the business, or this was a one-off purchase. So in that case, the UK courts took a wide notion of what consumer was and applied it to a company, notwithstanding the company was purchasing something for one of its employees. The European courts, on the other hand, at least traditionally, have taken a more restrictive approach, although when we look at some of the more recent case law, we'll see that that seems to be relaxing a little bit. But in the case of France and Di Pinto, for the purpose of the doorstep selling rules, the question arose whether somebody who was wanting to sell their business was acting as a consumer. So it's not a transaction made in the day-to-day part of what the business did. In fact, the person who owned the business wanted to get rid of the business. They wanted nothing to do with us anymore. And the European court said, no, that was acting as a business and therefore not as a consumer. And they interpreted the meaning of consumer as someone who is acting meaning of someone who's acting in the business is acting someone for other than the family or personal requirements of the trader. So if you're acting for your family or you're acting for your personal requirements, you're a consumer, but otherwise you are not. So in that case, the European court said, well, the fact that they are selling the business means it's not really personal or family requirements, therefore we're not acting as a consumer. It's possible to question that. I mean, if you're trying to get rid of the business, why are you doing that? Are you doing it because you want to retire, because you want to spend time on a beach, sort of sipping your cocktails? Is that not really your family life, personal life? You can see you could argue it. What then means it's business purposes if you're selling your business? Is it simply because you're trying to make money? Does the fact that you are trying to raise capital investment or money or whatever it is mean that you're acting for business purposes? That might be some explanation for the France Di Pinto case, but when we look at the more recent case law, we'll see that that actually currently probably doesn't stand up. So that's slide 2. Again, if you've got the slides, if you go on to slide 3, a few more. Again, taking a somewhat restrictive interpretation of the notion of consumer, the European courts had to consider in the case of Gruber and Baywa AG, whether somebody who made a purchase for both business and personal circumstances was acting as a consumer. This was, I think it was a farmer who was buying tiles for not just his farm buildings, but also his personal buildings. And what the European court said then is he was not acting as a consumer, notwithstanding the fact some of the purchase was for his own personal family use, because they said in a mixed purpose contract, unless the trade or professional purpose is so limited as to be negligible in the overall context of the supply, then you are not acting as a consumer. So it must be negligible. What does that mean? 1%, 5%, 10%? How many tiles did that farmer have to buy before he stopped acting for business purposes and being a trader? Or rather miraculously, how many did he have to put on his own personal roof rather than put on his farm roof? Well, it would seem to be quite a high number applying the test. One note of caution with that decision, though, that was in the context of the Brussels Convention. If you have regard to the recitals in the Consumer Rights Directive, what recital 17 says, and again you'll see this in the slide, is for that purpose a mixed contract is a consumer contract unless the trade purpose is so limited as not to be predominant in the overall context of the contract. So that would seem to be more of a 51-49% test scenario. So where you've got a contract for dual purposes under the Consumer Rights Directive, what the recital seems to suggest is the intention was that you're a consumer contract unless your business element is 51% or more, which is not the reasoning in the Gruber and the Baywa AG case. Next case we look at is Schrems and Facebook Ireland Limited. Mr. Schrems was a Facebook customer. I'm sure we all know what Facebook is. He used Facebook for his personal account, but had a bit of a falling out with Facebook. And what he then did was he used his Facebook page to start promoting his own business purposes. He would do talks explaining how he didn't like Facebook. He would then produce books explaining about his dispute with Facebook. He would try to advertise his talks, which he charged for. He would try to advertise his books, which he charged for on his Facebook page. And the question arose whether he was acting as a consumer. The European courts, on their face of it, initially approved the Gruber decision, but then seemed to backtrack a little bit, because what they found was given that he was originally acting as a consumer, he would only cease to be acting as a consumer if the use of his Facebook page had become predominantly professional. So he started out as a consumer, and unless the use of that medium or whatever it is becomes so business orientated that it sort of is predominantly for business purposes, then you will remain a consumer, notwithstanding your business purpose use, notwithstanding the Gruber and Baywa AJ position, which is it has to be negligible. So that would seem to be more of a shift towards the 49% test, which is, well, unless the business use is 51% of that medium, the fact that you started off as a consumer means that you stay as a consumer. That then takes us on to what I think I'm going to try and pronounce as Petruchova. I may well be wrong. Petruchova and FIBO Group Holdings is on slide 4. And that is a recent decision. It came out in the beginning of October, and is a decision from a university student in the Czech Republic. And what she liked to do, what Ms. Petruchova liked to do, was trade on the Forex market. And what FIBO Group Holdings would let her do was she didn't have to just trade with her own money. She was allowed to trade in what was called lots. And each lot was leveraged and was worth, I think it was $100,000. And she placed a trade for 35 of these lots on the currency position of yen. My basic maths means I think she was wagering $3.5 million on what was going to happen to the yen. Unfortunately, there was a slight problem with Petruchova's systems, and there was a 16-second delay in her placing her trade and it going through. And Miss Petruchova estimated that 16-second delay had cost her 3 times of her profit. And she took action to try and recover that. And the question arose as whether she could do so, whether she was acting as a consumer, and again, it arose in the context of the Rome regulation, what was the proper jurisdiction of the courts. So she wasn't being sued, she wasn't the person that had suffered loss, she was saying, I've made money, but I should have made more money, which isn't a great starting position for saying that you're acting as a consumer, but nevertheless, European courts found that she was. What they said was the amount of the transaction is irrelevant. Doesn't matter if you are placing a position on yen for £3.50 or $3.5 million. That's simply irrelevant to the question. The fact that she had previously traded was irrelevant. That didn't matter. The fact that there is large risks in the market is irrelevant. The fact that she had knowledge and expertise was irrelevant. What they seemed to concentrate on was simply that she had said, and it was unchallenged, that she was a student. So notwithstanding that she was a student that was placing £3.5 million wages on the yen market, she was still a consumer for the purpose of European law. The test is objective, confirming what had previously been decided in other case law. This does feel a little bit counterintuitive. I mean, if you've got, well, she didn't have 3.5 million yen, but she was able to wager on it. If you've got access to that kind of leverage things, it feels like, well, maybe you're not acting as a consumer. It feels like if you're placing those type of size gambles, is that not business purposes? Clearly she was doing it to try and make money. Does the fact that she is also a student take you outside the notion of being a consumer? Well, of acting for a business, sorry. Well, that's what the European court said exactly happened, which does leave you into a bit of a strange situation. You could have had exactly the same trade by another person who wasn't also a student. They just liked to trade in their attic, in their house, and just that was their way of making income. And they would be acting for business purposes, where the identical trade made by Miss Petruchova wasn't, simply because she was also, she said, acting as a student at the same time, and therefore the purpose of the trade was outside her, was for her personal family need. That was basically the decision. So that then moves us on to the 5th slide, which I've headed examples. A better heading would probably have been questions, because what I'm trying to do here is to give a few situations, and we will try and apply the reasoning we've heard in the previous decisions to the situations, see where we end up. I always like to start with a situation so outlandish that it could never possibly happen when I'm doing these. So the first of these examples is a barrister wants to pay his tax bill and can't afford to do so, so has to borrow money. Technically, I suppose this would probably be a case under the Consumer Credit Act rather than some of the other consumer protection legislation, but let's leave that aside for the moment. Would a barrister borrowing money for his tax bill, be acting as a consumer? If you're paying your tax bill, is that for your personal or family needs? I would suggest not, and I think De Pinto would probably support that. So I would say if it's tax purposes, feels to me like business purposes, notwithstanding the reason you're doing it is probably you don't want to get a heavy knock on the door from the taxman. Second of those examples I gave, a student purchases a new computer and uses it to invent Facebook, the Zuckerberg scenario. Mark Zuckerberg is worth an awful lot of money these days. One would have thought that when he started out Facebook, he was acting for the purpose of a business. But the Petruchova decision would suggest that he wasn't, because he was also, at the time, a student. So notwithstanding the fact that he has gone on to make an awful lot of money, he wasn't when he started out acting for business purposes. What the Schrems decision says, however, is that there will come a point when that's changed, when in fact the business purpose then becomes so predominant, the 51%. So at some point, I think everyone's going to agree that Mark Zuckerberg has probably stopped acting as a consumer and is acting for the business point. I suspect if a court ever had to do it, trying to define the exact moment that happened may be difficult, but I think we can probably all agree that he would probably now be acting for business purposes. The third bullet point, a doctor invests £7 million of his own money in investments, but his main job is a doctor. This was a situation that had actually come before the UK courts in a case called Apostolakis and Standard Bank. And Longmore J found in that situation that the doctor was still acting as a consumer because his main profession was a doctor, and the fact that he was investing £7 million here or there was irrelevant. His main profession was a doctor, therefore he wasn't acting for his business purposes. This was a decision that got actually quite a lot of criticism. It's been criticised both academically and it's not been followed in a few of the decisions. But post the Petruchova decision, it looks like it was actually probably correct, because the fact that the doctor was a doctor was enough to prevent him being a consumer, notwithstanding the fact, to make him a consumer, notwithstanding the amount of the large value transactions he was making. Fourth bullet point, an entrepreneur purchases tables and chairs for the purpose of a restaurant, doesn't quite get there, restaurant folds before he ever starts trading. Does that stop him acting for business purposes? Probably not, in my opinion. I think if you're buying your stock for your restaurant, doesn't really matter if you don't ever actually launch, you were still acting for business purposes. And the final one is an eBay trader purchases stock to sell at a profit on eBay. Well, this probably depends on what else the eBay trader does. Looking at the Petruchova matter, if the eBay trader, this is something they do in their evenings just to sort of pass a little time, then it may well be that they are still acting as a consumer, notwithstanding the fact that they are trying to make it profit, simply because that's not for it's outside of professional need, family need purposes. On the other hand, if this is their main income, if this is all that they are doing, then they would be acting for business purposes, which again feels slightly counterintuitive. One would have thought if it's the same trade, why does it really matter if you also have another main source of your income? But that does seem to be a little bit where the Petruchova decision has taken us. Okay, that is that in terms of the content of the slides. Ian, have we had any tricky questions over the internet?
Well, indeed, we do have a couple of questions here, Simon. I was just reflecting on the fact that to be a student in the Czech Republic with $3.5 million to play with. I fear you and I might not have used it as productively as Forex trading all those years ago. So you mentioned obviously the highly implausible scenario of a barrister having to resort to credit, and of course the word consumer features in many areas of law. One of which, of course, is the Consumer Credit Act, but it doesn't quite mean the same thing there, does it?
No, it's a slight misnomer, the Consumer Credit Act, because the Consumer Credit Act will cover credit not just to consumers. You can be borrowing for business purposes, and you will still potentially fall within the scope of the Act. What the Consumer Credit Act regulates is loans to individuals, which is defined as including small partnerships, 2 or 3 partners, unincorporated associations. It wouldn't cover body corporates. Where the notion of consumer comes in is in one of the exemptions. So there is a consumer credit exemption for business loans over £25,000, and the definition of business, from recollection, is you're acting wholly, predominantly for the purpose of business carried on by you. So not dissimilar to some of the tests we've been looking at, what does predominantly mean? Is it 51, 49%? Seems likely. But simply being a consumer or not being a consumer doesn't necessarily mean you're outside the scope of the Consumer Credit Act. If you are a sole trader borrowing for your business purposes, but the amount of your loan is £25,000 or less, you're still regulated.
Thanks very much, Simon. You'll be delighted to learn that we've also got a question about Brexit. Some people might have heard something about that over the past few months or years. But obviously we're dealing now with a decision of the Court of Justice of the European Union in Petruchova, or however we pronounce it. How are things going to change? Have you got a crystal ball you can assist us with as to how things might change in relation to that point of interpretation in the future?
I think all lawyers at the moment love questions about Brexit. The short answer is easy, we just don't know. But the slightly longer answer is, we know from the Withdrawal Act that what's supposed to happen is, if we ever get to Brexit, that all the decisions of the European Court of Justice, they remain binding, but post-Brexit, any subsequent decisions are simply persuasive. So all the case law we've been talking about still remains relevant. In theory, what could happen on Brexit +2 is that you have a decision of the European Court of Justice which the UK courts simply ignore. I'd be very surprised if that happens, simply because the definition of consumer in most of our legislation, at least for the moment, stems from European directives, and I suspect the UK courts will for quite a while still be heavily influenced by what the European Court of Justice says. But it will, in theory, assuming it doesn't change between now and then, not have the same weight as historic cases, which will still carry more weight.
There is a theory that there will be gradual divergence, isn't there? That we might start off being terribly respectful of CJEU decisions, but that respect might leak away over the years. But fundamentally, as you very rightly point out, nobody quite knows. So it's going to be a case of watching this space and asking a good lawyer, if you happen to know anything. Well, thank you very much for watching, everybody, and thank you very much, Simon, for that very informative talk. The next Gough Square Live is scheduled for the 5th of December. Topic and speakers to be announced, but they'll be publicised in the usual fashion. I hope you've enjoyed this morning's broadcast, and we hope to see you again soon.